Welcome to Literary and Jury Charge Practice. Let's get started with this literary material. It's an article from the NCRA magazine, and it's called Archival Storage of Steno Notes. Let's see what we can learn. Ready? At one point, archival storage of Steno notes was simple. Place your paper Steno notes in a box labeled with the date range, the destroy date, the judge, firm, or client you worked for, and any other important information. Today, archival storage of Steno notes is still simple, right? Maybe not, depending on the retention schedule that governs your archive system. And now that the majority of reporters write Steno paperless, we must now think in terms of digital performance. Aiming for digital permanence means reporters must consider data format, technology reliance, archival strategy, and digital rights management. For data format, consider which formats will be accessible both now and in the future. Technology reliance is perhaps not as large a concern in a specialized environment such as court reporting. Reporters should be able to safely assume that as new updates of CAT software come out, any prior note files should still be accessible. One caveat may be what happens when switching CAT vendors, but that is probably a limited group. Let's see, we might have had some challenging words in there. Permanence, digital permanence. That's spelled P-E-R-M-A-N-E-N-C-E. Digital permanence. Archival strategy. Archival strategy. Caveat. C-A-V-E-A-T. Caveat. All right, some challenging words to practice as we expand our vocabulary all the time. All right, let's move on to some jury charge practice. And this particular jury charge is regarding juveniles. Ready? In the criminal court system, a juvenile is to be given the same rights as an adult. A juvenile is to receive the same right to a fair, speedy trial. A juvenile has additional rights before the law. It is important for the juvenile to know his rights before the law. In a court of law, the individual actually has more rights before the law. As with an adult, a juvenile may be arrested. When a juvenile is arrested, the juvenile must be afforded the same rights as the adult. He must be told by the police what his or her rights are. A juvenile may be treated in a special way. If the police apprehend a minor for violating a statute, the individual may be treated in a special way. A juvenile is often detained in a correction facility. If an individual is of a certain age, he will be heard in a special court called Juvenile Court. The difference between Juvenile Court and the regular court that the adult is heard before is that in Juvenile Court there is no jury. Under normal circumstances, the individual has a right to be heard in front of a jury. In the case of a juvenile, the individual is not heard before a jury. It is for the protection of the individual. In this case, the juvenile in question will come before a judge who will hear the case. He will not face a jury of his peers. He is not to be heard in front of a jury of his peers because his peers may not be old enough under the law to make informed decisions regarding another person. The police are trained, as in the case of an adult, to inform the juvenile that he has certain rights that are granted to him or her according to the Constitution of the United States. The police treat the individual in much the same way as they would an adult. Juvenile crimes are treated in much the same way as adult crimes. The first step in the criminal process includes the arrest of a suspect. The first step in the criminal process involving a juvenile is much the same. Back to our literary regarding archival storage of Steno notes. Ready? When developing an archival strategy, especially for the long term. Consider what it will take to reproduce the archive, including subsequent hardware or system upgrades. Think in terms of the basic non-existence of floppy drives and disks. While today's USB drives are solid state and fairly robust, they too may see a day when a new technology proves to be more efficient. Regarding digital rights management, remember that these Steno notes are your work product. As much as possible, the reporter should be involved with any future production or reproduction of the Steno notes. At present, there is some uncertainty as to the lifespan of digital storage, including magnetic media, non-magnetic media, and solid-state memory devices. While retention schedules governing court reporters differ from jurisdiction to jurisdiction and from civil to criminal proceedings, Steno notes and files may need to be archived for an extremely long time, certainly longer than any of the guesstimates of the digital archive lifespan. In the state of Indiana, the general retention rule is 50 years for criminal proceedings. To date, there is not a magnetic digital format that boasts 50-year retrieval rates. We haven't yet reached 50 years since its inception. So we have retrieval rates, lifespan, guesstimates, archival strategy. There's that archival word again. Floppy disks and drives. Robust. Magnetic media. Solid state. This is a challenging one. All right, let's move on to some jury charge practice. We'll carry on with this one we started regarding juveniles and the law. Ready? The Constitution provides that there are a number of rights that the person has before the law. The juvenile has these same rights. One of these rights that everyone has is the right to an attorney. A juvenile will be informed that he has the right to an attorney. Another right is the right to a speedy and public trial and jury. The juvenile has a right to a speedy and public trial without a jury. As indicated, the juvenile is heard before a judge. There are reasons why it is necessary. Another right is the right to confront witnesses. Another right is the right not to testify against himself. He has the right to know his Fifth Amendment rights. These rights apply both to the adult and to a juvenile. Before a person is questioned, the person is supposed to be informed of his rights in a case involving an adult. A juvenile can use as a defense that his rights have not been afforded him. An important case decision is the Miranda decision that sets forth the principle that a person must be informed of his rights. These rights apply regardless of the age of the individual. The rights that a person is to be informed of is his right to an attorney and his right to remain silent. Just as an officer or officers who are taking a person in for questioning must inform the adult, the same is true for the juvenile. The officer or officers must inform the juvenile that he has those same rights. These rights have been set forth for him in the Constitution. However, it is the Miranda decision that requires that the person be informed of these rights. Individuals are informed of the right to an attorney and the right to remain silent when they are arrested. These are the rights that individuals must be informed of according to the court case involving an individual named Miranda. Let's see what else we have to learn about storage of Steno notes. Ready? Given the length of time for retention, reporters should back up their Steno notes separate from the file notes, in addition to using the latest, greatest digital technology available. In my CAT system, I can open my notes files separately and then copy-paste them into a separate file. Once they are copied and pasted, they become a PDF file. once I've made PDF files, I can do two things. I can simply digitally store the files separate from the file backups in my system, or I can decide if the files will require a longer retention schedule. If it's the latter, I print the files on paper for storage, making sure I follow archival guidelines like using acid-free paper and not storing them in 3-ring binders, etc. While the suggestion of printing PDF files on paper may seem a step backwards, consider that less than a year ago, Google's vice president discussed the information black hole that we face in the future if text materials that only live digitally are lost when out-of-date files can no longer be recovered. All right, that will conclude our literary and jury charge practice. Thank you.